Welcome to this video lecture. The video lecture is titled Procedures for the Planning of New Infrastructure. My name is Fred Hopma and I'm Associate Professor of Planning and Development Law. In this video on the procedures for the planning of new infrastructure, we will not discuss infrastructure construction contracts. So, for instance, we will not discuss the DBFMO contract, the contract that includes design, build, finance, maintain and operate of new infrastructure. In this type of projects, we will see a client, usually government, contracting with a special purpose vehicle. And the special purpose vehicle incorporates the contractor, the designer, the engineers, and the maintenance firms. Those parties will work together within one special purpose vehicle. The topic of this kind of infrastructure contracts falls without the scope of this video lecture. It will be discussed in the video lecture on construction contract law. Our lecture will deal with the infrastructure planning procedures. If we take a closer look at the infrastructure planning procedures, we can see there is a lot of national autonomy and there are European Union influences on national planning procedures. There is no special European procedure, no specific directive for the planning and construction of new infrastructure within the EU. That implies that there is a lot of national autonomy for member states. However, there are EU influences on the national planning procedures. And in some way there is unity in planning procedures among EU member countries. And that is because certain directives apply to all of the EU member states, and those directives indirectly have effect on infrastructure planning. Let's take 3 examples of those directives having implications for national planning procedures. In all EU countries, the Environmental Impact Assessment Directive applies. This directive is for projects and for programs. And in the Netherlands, these directives are fully integrated in the statutory procedure for infrastructure planning in the Infrastructure Planning Act of the Netherlands. Second, in all EU countries, the Habitats directives for species and their habitats and the Wild Birds Directive apply. Those directives will certainly have consequences for infrastructure planning decision making. And third, in all EU countries, the Clean Air directives apply. Those 3 directives will have indirect impact on national infrastructure planning procedures. So although there is no specific directive and therefore, there are differences between EU member states as far as national infrastructure planning procedure is concerned. There is some kind of harmonizing effect because of the EU directives. Let me give an example of the impact of those directives on a well-known motorway project in the Netherlands. This is a Dutch example of a project in which several EU directives were at play in the extension of the A4 motorway between The Hague and Rotterdam. Here is The Hague, here is the Rotterdam area, and the example deals with the extension of the A4 motorway, the construction of this new part of the motorway. The project is now finished, but for many years there were problems related to the environmental impact assessment. There were battles over the figures of the data of the impact assessments. There were also problems related to the Clean Air Directive. because the air quality in the area is not so good, and of course the EU standards have to be met. A third EU directive that had impact was the Habitats Directive, in particular the nature compensation. So the project damaged some nature and compensation has to be guaranteed because of the EU directives. So 3 issues were covered by European legislation: environmental impact, clean air, and nature compensation. This example shows that EU directives indirectly have impact on the infrastructure decision making. We have to make a distinction between law and policy. In this video lecture, we will discuss legal aspects of infrastructure. But here's an example of policy related to infrastructure planning. The Trans-European Transport Network. These are community guidelines for the development of the Trans-European Transport Network. And the Trans-European Transport Network comprises infrastructures such as roads, railways, waterways, ports, airports, navigation aids, intermodal freight terminals and product pipelines, together with the services necessary for the operation of these infrastructures. And the European Commission compiled a list of 30 priority projects, and the total cost is estimated at 225 billion euros. We can find 2 Dutch projects on this list, among others. First, the high-speed train Paris-Brussels, Brussels-Cologne, Amsterdam-London. And second, the conventional rail combined transport Betuwe-lijn. Both projects at this moment are finished. This is an example of policy, and policy will not further be discussed during this lecture. So far, we've seen that new infrastructure has to meet national legislation and European legislation, but there is international legislation on infrastructure too. For example, the European Agreement on Main Infrastructure Traffic Arteries. It refers to the E-roads. This is a UN treaty about the geometric characteristics of roads. Many countries have adopted this agreement. And the agreement holds conditions to which the main international traffic arteries should conform. Geometric characteristics. This treaty refers to, for example, the allowed curves of a motorway and the width of safety lanes. The treaty, however, does not relate to infrastructure planning, so we will not further discuss this topic. Okay, we've seen that there is no EU directive directly relating to infrastructure planning, and therefore national procedures for infrastructure vary between countries. However, there are similarities between European countries in infrastructure planning procedures. What are those similarities? Apart from the harmonizing effect of some EU directives, we see that many EU countries have comprehensive and lengthy procedures and are unsatisfied with that. And in some EU countries, initiatives are taken to reduce the complexity and uncertainty of the planning system. For example, in the United Kingdom, the Addington Transport Study in 2006 reported several problems with the planning system. In the Netherlands, important was the report of the Commission Elverding and a report by the Commission Ruding. In Belgium, the Commission Burks published a report on problems with infrastructure planning. All these reports led to changes in procedures for infrastructure and led to changes in the legislation for infrastructure. The analysis of these reports is that procedures gradually have become more and more complex and now take too much time, which is unsatisfying. We must also be aware that there is international competition between countries. Infrastructure is a business location factor, so infrastructure needs to be of good quality and provided in time. These reports in several countries started initiatives to speed up the decision-making process through a greater involvement of the public in decision-making at the beginning of the process. The idea is to try and include the public's opinion at an early stage, if possible, to increase the quality of the decision-making and also to prevent legal opposition later on in the process. The initiatives to speed up the decision-making were also started through using an area approach instead of an infrastructure approach. What do we mean by this? We mean that it's not just about making an infrastructure project, but broaden it into an area-based project so that it includes, for example, the improvement of local and regional roads, connecting the new infrastructure to an existing industrial estate so that employment is enhanced, soil cleanup in the area, the improvement of existing nature, etc. So widening the project from purely infrastructure to other issues that are at play in the area. Both approaches also aim at preventing or mitigating opposition from citizens and environmentalists. If we can prevent or mitigate opposition by using the two ideas on this slide, the speed of decision making is increased as well. That is the idea. In relation to infrastructure, we must devote some attention to a special act in the Netherlands, the Crisis and Recovery Act. This act can be seen as a reaction to the financial and economic crisis around 2008-2009. It aims at giving a stimulus to the economy and in particular the construction industry to prevent unemployment. We can compare it with initiatives like the construction of the Afsluitdijk in the 30s of the previous century. The belief of the ministers is government merely granting a budget for new infrastructure developments will not stimulate the economy because legal procedures hinder immediate realization of the project. The logical consequence is legal barriers must be removed, and the Crisis and Recovery Act is instrumental in that. The Act was adopted by Parliament early 2010. Now we come to infrastructure. The Act holds a list with approximately 100 projects, infrastructure and urban development, to which the special procedures of the Act apply. The Act was and still is much contested in society. There have been protests because quite some people and organizations were of the opinion that speeding up the decision would be at the expense of environmental protection and at the expense of legal protection against governmental infrastructure decisions. Then what are the main contents of this Act? These are the main contents. There is no right of appeal for municipalities and provinces against national governmental decisions on infrastructure. Furthermore, the right of appeal for citizens exists only if the issue they raise refers to their personal interests. So, a person cannot raise an issue in court to assert another's interest, such as future residents' interest. That is not possible anymore. Furthermore, small legal flaws in an administrative decision do not necessarily lead to nullification if nobody is harmed by the deficiency. Another topic in this act. There is less environmental research needed prior to a governmental decision. And finally, there's an exemption for 10 years to reach environmental standards for the projects that fall under this act. So, for example, new houses can be built close to existing industry if it is expected that within 10 years the industry will leave the area. And in the meantime, the new inhabitants, of course, will be confronted with the environmental nuisance. These are some of the aspects of the Crisis and Recovery Act meant to speed up the construction of new infrastructure by taking away legal barriers. In another video lecture, I will discuss the Dutch Specific Infrastructure Planning Act.